Hello there. We will be talking about the Tolenoa versus Denny's case that concluded on February 7th, 2011. Team 2 includes Sam Channon, Natasha Howe, and Bingley Ma.
In this case, we have three plaintiffs. One of the plaintiffs, named Stephen Tolenoa, is pictured above. The other plaintiffs include Lisa Beltran Walker and Carl Walker. The Walkers are a married couple. The defendant in this case is Denny's and Linda Hoffer. Hoffer was the area manager for the region, which includes the specific Denny's discussed in this case. So, to get it started, on January 21st, 2007, Tolenoa went to Denny's in Kent, Washington at 2 a.m. during its bar rush. The bar rush is when a predictable, large group of rowdy and drunk people rush to Denny's after the bars and lounges close at about 2 a.m. to keep the night going. Frank Evans, who attended a nearby club, came to Denny's after getting into a verbal altercation that ultimately turned physical. Evans walked into the Denny's threatening to hurt customers, but was pummeled and left with a damaged ego. He proceeded to get a gun from his car, came back in, and fired 11 shots, injuring 5 customers, including Tolenoa, who is left quadriplegic. Carl Walker, another customer, was not shot, but was traumatized by having a gun in his face and concerned for his wife's life. Lisa Beltran Walker, Carl's wife, meanwhile, was hit by a bullet in the back of her leg, resulting in some residual numbness. She also suffered from emotional distress. Tolenoa, meanwhile, would never be able to walk/work again and have to spend the rest of his life in a bed or wheelchair. As for how the case was tried, it was tried on the legal duty of an owner of commercial premises to protect its customers from reasonably foreseeable harm and criminal violence. It should be mentioned that this Denny's had a history of violent acts during its late night shift, in particular during the bar rush.
The history of violence resulted in 1,136 total calls being made to 911 from this Denny's in the 2 years prior to the shooting. Also, there were no security guards or off-duty officers, and the manager was in the back of the restaurant during the incident. Denny's corporate management knew of the recurring violence at its 1,600 restaurants during this bar rush, but chose to do nothing with regards to security because the late night produced 25% of Denny's profits. The court would be sure to order Denny's CEO and CFO to appear and testify in King County, Washington. When called upon, the CEO and CFO said they didn't know about the violence and the issue never came up. This was a lie. Employees at the Kent Denny's were scared to work during the bar rush, and the manager of the late night shift said they were always on the verge of calling 911 during that time. Both the manager and employees asked for security but did not get a proper response from the general and area manager. The plaintiffs would ultimately ask the jury for $20 million plus in economic damages and left non-economic damages, which means pain and suffering, up to the jury's discretion. The defendant, meanwhile, would ask the jury for a defense verdict of $3 to $5 million to purchase an annuity for Stephen Tolenoa. The issue in this case is if Denny's was being negligent. Specifically, should Denny have hired security guards or off-duty police? Also, should Denny's have closed the restaurant during the bar rush? With regards to the rule of law, this case was tried on the legal duty of an owner of commercial premises to protect its customers from reasonably foreseeable harm and criminal violence. Now Binglin will talk about the analysis.
The court said evidence that influenced them most was in the manager's logbooks and in the surveillance video. With regards to the logbooks, the plaintiffs showed entries from the Kent Denny's manager's logbooks between January 2005 and January 2007. These entries documented numerous pre-incidents of violence and explicitly portrayed the fear, concern felt by employees during their bar rush shifts. The most significant entry, which was entered less than 2 weeks before the shooting, included an employee saying, "Dave, please don't forget to call security regarding getting police here on the weekends. I had to call police last Saturday night and it's only going to get worse." With regards to the surveillance video from the night of the shooting, it was used by the plaintiff's graphic artist to display specific security measures. These measures include having a patrol car parked outside, which, if had been the case the night of the shooting, would have discouraged Evans from entering. Also, the officers in the patrol car could have stopped, disarmed, or arrested Evans if he had tried re-entering with a gun. With regards to the jury's findings, it found Halford negligent, but no proximate cause. They also found Dennis negligent and 100% liable. With regards to the two empty chair defendants, the shooter and his friend, the jury did not found them to be at fault. The verdict, meanwhile, was allocated among the plaintiffs as follows. The plaintiffs were awarded $46.4 million in compensatory damages. It was compensatory damages because Washington prohibits the award of punitive damages. With regards to how the money was distributed, the majority money went to the Steve Tolenoa, and $54,477 went to the Lisa Walker, and another $15,000 went to Carl Walker. The plaintiffs, however, agreed to a $13 million settlement from Denny's insurance carrier. On the next few slides, you will see how the original $46 million was broken down. As you can see, Tolenoa received a majority of his money from future non-economic damages and future economic damages. With regards to Lisa Walker, she received a majority of her money in past non-economic damages and future non-economic damages. Last but not least, Carl Walker received all of his money in the form of non-economic damages. This is the end. Thank you.